Constitutional Government, Module 2, Law and Money, Part 1, Law. In order to fix something, one must know what's broken. In other words, filling the tires with air is not going to fix the no-fuel problem. Yet, that's exactly what is happening. Until we understand the basic principles being used against us, we cannot fix the injustice. The purpose of this module is to identify areas where government and corporations manipulate and control men and women, to identify alternative systems, to provide enough material to encourage further research, to provide a tool to create conversations with friends and family about the convention's process, to teach leaders about one of the key pillars of a constitution. Our ultimate goal of the convention's process is to seat a constitutional government. It's a strange web they weave when it comes to money and law. Do the laws, or what we believe are laws, control our monetary policy? Or does the money from corporate lobbyists control the statutes we call laws? At what point are the rules of the game too complicated or too numerous to warrant even playing the game? Are the criminals making the laws, or are the new laws turning decent people into criminals? When is enough enough? At what point are we, the people, asked to give our consent to these laws? Never.
As with everything in our history, deceit and corruption undermines anything good that it has achieved. When the foundation of a nation is built on backroom deals, deceit, corruption, and coercion, where is the honor in it? The Supreme Court of Canada floundered its way into existence. Section 101 of the Canada Act, which is the 1867 British North American Act, or letters patent for the Governor-General, allowed Canada to set up a General Court of Appeal. It was not the highest court, however. That role belonged to the Judicial Committee of the Privy Council in London. It should also be noted that the same 6 judges who sat on the Court of Appeal also were judges in the courts that they were hearing the appeals from. What? The same judge could conceivably retry a case he already ruled on? Where's the justice in that? Members of Parliament almost abolished the court, saying there isn't enough work to warrant the pay. That all changed when the Dominion of Canada ended with the Statute of Westminster in 1931. The Judicial Committee of the Privy Council stopped hearing the appeals. They no longer had jurisdiction over Canada. But Canadians being Canadians hardly even missed it until they needed it. Section 101 of the Canada Act is very vague about the roles of the courts. So how can it possibly even be considered a constitution for the country? So anyway, the General Court of Appeals assumes the role of Supreme Court of Canada. Wait a minute. There is no Dominion of Canada as of 1931. How does this court have any standing in law whatsoever? Well, in 1947, with Mackenzie King fabricating new letters patent, the construction of a massive new courthouse was underway. In the very vague section of the Canada Act 1867, Clause 101, there were no provisions for the structure of a federal judicial system, in that the Chief Justice did not have the authority or the power to impose his authority on his fellow justices. Instead, it relied on the force of his personality. They did not have the authority, but very quietly in 1950, without formal recognition, the Supreme Court of Canada sat in its grand new building. Nothing sneaky being done here. The struggle between the provincial upper courts and the Supreme Court of Canada continued on without any clear lines of authority. Several statutes amended Section 101 of the 1867 Canada Act. It's not clear how they could lawfully amend the 1867 Act, but that didn't seem to bother them in the slightest. Statute upon statute gradually reduced the provincial jurisdiction and elevated the Supreme Court's authority. The de facto government went about their deceptive ways, creating the Bill of Rights in 1960. Quebec was the least infatuated with the de facto government's enactments. Quebec wanted to leave this arrangement, so the de facto had to make some serious adjustments to the Supreme Court of Canada's jurisdictional authority. The year 1982 ended a period of change and development. It gave the Supreme Court of Canada full authority to override any upper-level disputes, as well as to create other courts it deemed necessary. The Canada Act 1982 was actually the Government of Canada's incorporation. That placed the Canadian courts squarely under Admiralty Maritime jurisdiction. Criminal law under common law jurisdiction was now replaced by the Criminal Code of Canada, removing it from the provincial to the federal jurisdiction, with the provincial courts administering the proceedings. This not only changed the way criminal law was administered, it also gave precedence to how registries could enforce adherence to their new policies. These registries are now administered provincially, but regulated federally. Your birth certificate and your social insurance number are actually certificates of incorporation. The process of enfranchisement happens when you're born. Your parents are told to fill out the forms at the hospital, giving your name. Parents are not told that this is a certificate of enfranchisement, and that is totally fraudulent. You are told that in order to get a job, you must apply for a social insurance number. This way, they can tax your income as of 1948. It's not taxing you, the man or woman, but your legal fiction. Stats Canada wants to be able to track every transaction that occurs under that identity. In the past few years, there have been many discussions about it. The Privacy Act was implemented in 1974, which allowed the government to actually collect more data, but in specific ways. Oh, wait, did you know? In 1983, the federal government created the Tax Court Act and implemented the tax court, along with defining its jurisdiction over the multitude of sections within the numerous acts. Was that done with our consent? Whenever the government sees themselves exceeding the limit of the current laws, they just create another law or a statute if the payoff is big enough. Does anybody remember the SNC-Lavalin affair? You would think that one day these bureaucratic geniuses will tie themselves into so many knots they'd render themselves useless. I believe that day has come. Now that we know a little bit about the judicial system in Canada, let's take a look at the so-called democratic process that goes into creating the laws. The parliamentary process of making law is supposed to be a democratic way of governing, but is it really? How many times in Canadian history were laws passed as an order in council? Did they ever go through the parliamentary process? Were any of these orders ever dropped? One has to ask, is our society so dense that it needs government legislation to wash your hands? Do we really need to employ a couple hundred people with huge salaries and pensions to make new legalese every year? At what point are we going to become grown-ups so that we can actually determine what's good or bad for ourselves without the nanny government telling us what we need? How do we hold these so-called lawmakers accountable? We cannot hold Jody Wilson-Raybould accountable for writing the omnibus legislation, lumping a dozen bills together in one document, if she even wrote it. We cannot hold any MPs who voted on the clauses in each bill accountable for their decision. Is that really a democratic process? It seems to me it's a very clear miscarriage of justice. Who wanted that legislation? Bill C-75, Bill C-48, Bill C-29, M-101. I could take the time to explain each of those bills, but better yet, you can go to the government website to see for yourself what those bills are about. These were not bills about men and women, but men and women have to live under them and pay for them without having any real weight in the decision-making process. How are new bills brought up in the House of Horrors to begin with? Were they a ploy to make work for politicians so it appears that they're doing something beneficial for the people? What industry would benefit the most? Could it be corporations or industries using lobbyists, bribing in some cases, that have a vested interest in the outcome of the legislation? Let's take a look at the way industries use lobbyists making use of the private bill legislative tool to influence the legalese makers. The process of a private bill legislation is somewhat different from public bills in how it is introduced to the House. The private bill is introduced by means of a petition, which is signed by the interested parties and presented to the House by the member who has agreed to sponsor it. Parliamentary agents are authorized to promote private bills and find sponsors. Who pays the parliamentary agents? Members are forbidden to act as parliamentary agents or to accept payment for presenting bills. Lobbying is a mega industry in Canada. Professional lobbyists are paid huge amounts to influence our legalese makers. They get better paid when their influence goes largely unnoticed by the public, yet are successful in turning the tide for social acceptance or bringing the majority of the party members to agree to the proposal. But if the reasons why companies lobby are obscured, it's always a tactical investment. Whether facing down a threat to profits from a corporate tax hike or pushing for market opportunities such as government privatizations, vaccines, lobbying has become another way of making money. Here is one tactic that lobbying businesses will follow to bend government to their will. It's called control the ground. Lobbyists succeed by owning the terms of the debate, steering conversation away from those they can't win and onto those they can. If a public discussion on a company's environmental impact is unwelcome, lobbyists will push to have a debate with politicians and the media on the hypothetical economic benefits of their ambitions. Once this narrowly framed conversation has become dominant, dissenting voices will disappear and appear marginal and irrelevant. It doesn't seem to matter if the new frame relies on fabrication, or another word for a lie. Everybody's doing it, including lobbying for fracking and nuclear power, public sector reform, bank regulation. An example would be the referendum on an alternative voting system, which was not as anticipated so much a conversation about the merits of first past the post. The no side was very quick off the mark to make it about the cost to the public purse. They led with the claim that switching to an alternative voting system would deny troops badly needed equipment and sick babies incubators. The yes camp lost the vote 2-1. Can you put a finger on where lobbyists have controlled the narratives on things like Oh, let's say a global pandemic. Now, there's a multi-purpose Trojan horse. Governments could use it to force the public into solitude, thereby controlling the civil unrest that is not only in Canada, but happening globally. The pseudoscience industry, such as vaccine research and virologists, managed to make their voices heard and a lot of money, while the climate scientists have been put on hold. But rest assured, they're developing the next climate emergency. The global push for mandatory vaccines is advertised daily by health officials. Both federal and provincial governments are doing their part in controlling the narrative by censoring any media that covers factual reports by the few moral scientists and doctors remaining in the sector. Social pressure is being applied by the government, sponsored media, and propagandists. The international banks and the Bank of Canada are using it as a cover-up for their fiat black hole. The fines the police are charging for non-compliance is another form of heavy-handed government control, as well as money-generating tactic for the legal system. The telecommunications industry is using the pandemic and lockdown as a way to install and push 5G technology, using the social distancing regulations for facial recognition. One has to ask, how does social distancing make a difference? What industries are currently lobbying our government for more regulations or deregulation? Why does the government of Canada need to know how much money is in our bank account or where we spend our money? Why does it employ pseudoscientists? I call them pseudoscientists because they are hired specifically to build models that will reflect the specific outcome that the government needs in order to push the agenda. How does the power industry benefit by lobbying to regulate pipelines and oil? How does the oil industry benefit by lobbying the government about the green energy industry? How did the banks pressure government to make oil companies invest in green energy? Why did the Bank of Canada adopt the new green incentive loan policy? How does the banking industry benefit from all of the above? How does the lobbying industry benefit from all of the above? The point is that individuals and small businesses cannot stand up to these corporations paying lobbyists to influence government. That was never made more clear than during this pandemic, where large corporate stores like Home Depot were allowed to stay open while small businesses were forced to close shop. And we, the people, keep sucking it up and paying for it. How could clauses in the Constitution address this situation? Would a simple clause fix this, or do we need a complete change of system, including the courts and the process of making laws? How could a constitution fix that? Stay tuned for the module, What is a Constitution? When structuring a new nation, one has to consider how it will do business on an international as well as on a national level. In order to do that, one also must have a basic knowledge about the world law systems. Before I get into the law legal descriptions, I'd like to clarify the difference between law and legal. Legal is the maritime admiralty jurisdiction. Law is the common law, equity, tort jurisdiction. It's not my intention to get into deep discussions about each of these systems. My intention is to give you enough information to start doing your own research, to conclude for yourself what type of system would work best to protect men and women. To understand who uses what system, the following resources will help you to determine the type of legal system in a particular jurisdiction and primary sources of law within that jurisdiction. The Foreign Law Guide, Juraglobe, and the CIA World Factbook. To get a brief description of the different law legal descriptions or systems, I went to the South Carolina Law Library's Guide to International Law Research website. Civil law systems have their origin in the Roman legal tradition. Civil systems vary widely, both in procedure and substantive law. So conducting research on a particular nation's civil law system should also include looking at the nation's specific system of law. But they do have some trademark characteristics. Nations with civil law systems have comprehensive, frequently updated legal codes. Most importantly, case law is a second source in these jurisdictions. France and Germany are two examples of countries with a civil law system. Quebec also uses a civil system. Case law, according to Merriam-Webster, is law established by judicial decision in cases. What does that mean? The outcome of one case sets the precedent for judgment on any similar case. Precedent then determines the law. The definition of precedent, according to Merriam-Webster, is an earlier occurrence of something similar. A second definition is something done or said that may serve as an example or a rule to authorize or justify a subsequent act of the same or analogous kind, a verdict that had no precedent. The convention established by such a precedent or by long practice. A person or a thing that serves as a model. Common law systems, according to the Cambridge Dictionary, is a system of laws based on customs and court decisions rather than on written laws made by Parliament. Common law forms the basis of the legal system in the United Kingdom, United States, and various other countries. According to the Law Dictionary, the distinguishing characteristic of common law is that it is based more on precedent than on a codified set of laws and regulations. Judges hold immense power in the common law system, since the decisions that a court makes are then used as a precedent for future court cases. While common law systems do have laws, they are created by legislators. It is up to the judges to interpret those laws and apply them to individual cases. To do this, judges rely on the precedents set by previous courts. When both judge and jury are used, they have distinctive roles in the common law trial. Judges play the role of legal advisor, instructing the jury as to the relevant laws to ensure that the trial is run fairly. When the arguments have been completed, the judge advises the jury as to the laws it must consider and how to treat the evidence as it's heard. The jury's task is to assess the evidence and arguments and make decisions about the facts of the case. The jury then makes the ultimate verdict, guilty or innocent, liable or exempt. In common law countries, certain courts, such as the Supreme Court of the United States, have the ability to strike down laws that were passed by legislators if those laws violated the law of the land, meaning the Constitution. But Canada does not have a constitution. In Canada, is it possible that the statutes and acts passed by Parliament have bastardized the common law system by superimposing maritime admiralty codes on common law jurisdiction, using a fake constitution as a principle for doing so? Equity law. Quoting from the U.S. Legal Dictionary, the word equity has the following meanings. Number one, the body of principles constituting what is fair and right for the natural law. It could refer to fairness, impartiality, or even-handed dealing. For example, as per the company policy, managers should use equity in dealing with subordinate employees. Number two, the principles of justice used to correct or supplement the law as applied to particular circumstances. For example, the judge decided the case by equity because the statute did not fully address the issue. In this sense, it is also termed natural equity. Number three, the system of law or body of principles which originated in the English Court of Chancery, which has superseded the common law and statute law when there was a conflict between the two. A right, interest, or remedy recognized by a court of equity. Number five, the right to decide matters in equity or equity jurisdiction. Number six, an ownership and interest in the property, especially a business. For example, A gave her equity in the business to B. Number seven, a share in publicly traded company. For example, A did not want to cash in his equity. While common law considers precedent, the laws are not always determined by precedent. Tort law. According to Merriam-Webster, a tort is a wrongful act other than a breach of contract for which relief may be obtained in the form of damages or injunction. I went to tortlaws.com. There are 4 elements to tort law: duty, breach of duty, causation, and injury. In order to claim damages, there must be a breach in the duty of the defendant towards the plaintiff which results in injury. There are 3 main types of torts. Those are negligent, strict liability or product liability, and intentional torts. Customary law systems are based on patterns of behavior or customs that have come to be accepted as legal requirements or rules of conduct within a particular country. The laws of customary legal systems are usually unwritten and are often dispensed by elders, passed down through generations. As such, customary law research depends greatly on the use of secondary sources. Oftentimes, customary law practices can be found in mixed legal system jurisdictions where they've been combined with civil or common law. Religious legal systems are systems where the law emanates from texts or traditions within a given religious tradition. Many Islamic nations have legal systems based in whole or in part on the Quran. Mixed legal systems refer to legal systems where 2 or more of the above legal systems work together. Most of our so-called laws are about money. Think, what type of system would best serve to provide equality for men and women under the law? Would eliminating the voluminous acts, trade regulations, trade agreements, and treaties serve us better? Would a simpler system serve us equally as well? What kinds of law system do we need for domestic business or international business? What if we could limit the power of corporations to level the playing field for the individual? What if there was a whole world of people wanting to limit the power of industries and big business? Could our small country set a world precedent? I would like to thank Doug Force for his unending patience with my unending questions. It's those questions that brought these modules about. By the way, there are no stupid questions. So if you have any,